Welcome back. The Senate Committee on State Affairs will come to order. The chair lays out as a matter of pending business Senate Bill 2451. Senator Menendez moves that we reconsider the vote by which Senate Bill 2451 was reported to the full Senate during our March 30th hearing.
Whatever you want, and so I'm fine.
No, it's okay. Is there objection? Hearing none, it's so ordered. Senate Bill 2451 is now before the committee. Senator Menendez sends up a committee substitute, and you're recognized, Senator, to explain the substitute.
Thank you, Mr. Chairman. The committee substitute simply is a ledge council draft, that's all. There were no differences in the bill that we passed unanimously out of committee on Thursday. As a little reminder, the bill deals with the font size and a few small layout changes in order for folks voting by mail not to have any confusion so that they can read everything. And as you will be able to see, there are no substantive changes in the committee sub, and look forward to everyone's votes. Thank you, Mr. Chairman.
Thank you, Senator. Members, any questions for Senator Menendez? Senator Menendez moves adoption of the committee substitute. Is there objection? Hearing none, the substitute is adopted. Senator Menendez moves that Senate Bill 2451 as substituted be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Yes. Birdwell. LaMantia. Menendez. Middleton. Parker. Perry. Schwartner. Zaffarini. Paxton. Hughes.
Yes. There being 7 ayes and no nays, Senate Bill 2451 as substituted will be reported favorably to the full Senate. Senator, you want Senator Menendez moves that the committee substitute to Senate Bill 2451 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, so ordered. The chair lays out as a matter of pending business Senate Bill 1768. 1768 by Senator Creighton. That's the one about correction or removal of obsolete provisions of the property code. Senator Parker. Senator Parker moves that Senate Bill 1768 be reported favorably to the full Senate with the recommendation that it do pass and be printed. We're on 1768. Will the clerk call the roll?
Betancourt. Yes. Birdwell.
Aye.
LaMantia. Menendez. Middleton. Parker. Perry. Schwartner. Zaffarini. Paxton. Hughes.
Yes. There being 9 ayes and 0 nays, Senate Bill 1768 will be reported favorably to the full Senate. Senator Parker moves that Senate Bill 1768 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, so ordered.
Can I make a motion to be voting aye on the first bill? I think I missed a vote, didn't I?
Yes, sir, you did.
The chair lays out as a matter of pending business Senate Bill 1846. 1846, that's Senator Creighton's bill about voting machines manufactured by certain foreign persons. Senator Creighton moves that Senate Bill 1846. Oh, Senator Betancourt, I'm sorry, I missed. Senator Betancourt moves that Senate Bill 1846 be reported favorably to the full Senate with a recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Aye. Birdwell.
Aye.
LaMantia. Menendez. Middleton. Parker. Perry. Schwartner. Zaffarini. Paxton. Hughes.
Aye. There being 9 ayes and 0 nays, Senate Bill 1846 will be reported favorably to the full Senate. Senator Betancourt to move Senate Bill 18. Senator Betancourt moves Senate Bill 1846 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, is so ordered. The chair lays out as a matter of impending business Senate Bill 220 by Senator Betancourt. That's the bill about enforcement of laws relating to elections. Chair lays out the committee substitute to Senate Bill 220. Senator Betancourt moves that the substitute be adopted. Is there objection? Hearing none, it is adopted. Senator Betancourt moves that the committee substitute Senate Bill 220 be reported favorably to the full Senate with the recommendation that do pass be printed. Will the clerk call the roll?
Betancourt. Aye. Birdwell. Aye. Lamatia. Menendez. Middleton. Parker. Perry. Schwartner. Zaffarini. Paxton. Hughes.
There being 7 ayes and 2 nays, Senate Bill 220 will be reported favorably to the full Senate. The chair lays out now as a matter of pending business Senate Bill 823, Senator Betancourt's bill on elections administrators. The chair lays out the committee substitute, Senate Bill 823. Senator Betancourt moves that we adopt the substitute. Is there objection? Hearing none, the substitute's adopted. Senator Betancourt moves that the committee substitute, Senate Bill 823, be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Aye. Birdwell. Aye. Lamatia. Menendez. Middleton. Parker. Perry. Schwartner. Zaffarini. Paxton. Hughes.
Aye. There being 7 ayes and 2 nays, committee substitute Senate Bill 823 will be reported favorably to the full Senate. The chair lays out as a matter of pending business Senate Bill 1750. The chair sends up the committee substitute. Senator Betancourt moves that the committee substitute be adopted. Is there objection? Hearing none, the substitute is adopted. Senator Betancourt moves that the committee substitute to Senate Bill 1750 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Aye. Birdwell. Aye. Lamatia. Menendez. Middleton. Parker. Perry. Schwartner. Aye. Zaffarini. Paxton. Aye. Hughes.
Yes. There being 7 ayes and 2 nays, the committee substitute to Senate Bill 1750 will be reported favorably to the full Senate. The chair now lays out as a matter of pending business Senate Bill 1933. 1933. The chair lays out the committee substitute. Senator Betancourt moves that the committee substitute be adopted. Is there objection? Seeing none and hearing none, the substitute is adopted. The chair now, Senator Betancourt moves that committee substitute Senate Bill 1933 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Aye. Birdwell.
Aye.
Lamatia. Menendez. Middleton. Parker. Perry. Schwartner. Zaffarini. Paxton. Hughes.
Yes. There being 7 ayes and 2 nays, Senate Bill 1933 as substitute will be reported favorably to the full Senate. The chair now lays out as a matter of pending business Senate Bill 946. Senators, that is Senator Sparks' bill about the election date for bonds, tax increases. Senate Bill 946. Bless you. Senator Betancourt moves that Senate Bill 946 be reported favorably to the full Senate.
Chairman,
Senator.
is this the bill that moves the date, the elections to November?
Yes, sir. This is the one that puts them in November. It was Senator Sparks' bill, 946.
Got it. Thank you.
No, yes, sir. Thank you. So 946, Senator Betancourt moves that Senate Bill 946 be reported favorably to the full Senate. We're on Senate Bill 946 to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Aye. Birdwell.
Respectfully, Chairman, nay.
Lamatia. Menendez. Middleton. Parker. Perry. Schwartner. Zaffarini. Paxton. Use.
Aye. There being 7 ayes and 3 nays, Senate Bill 946 will be reported favorably to the full Senate. The chair lays out as a matter of pending business Senate Bill 1993. The chair sends up the committee substitute and recognizes Senator Middleton to explain the substitute.
Thank you, Mr. Chairman, members. This this committee substitute raises the bracketing or the counties that it applies to 2.7 million or above, which at this point would only be Harris County. Additionally, the committee substitute requires that they actually do run out of paper, which was the original intent of the bill. That's just a point of clarification for committee substitute for Senate Bill 1993. So counties only above 2.7 million, and the second requirement that they actually exhaust their paper supply after requesting paper for more than 2% of the polling locations and not receiving it for more than 1 hour.
Thank you, Senator. Members, any questions for Senator Middleton on the substitute? Senator Middleton moves that the substitute be adopted. Is there objection? Hearing none, it is adopted. Senator Middleton moves that the committee substitute to Senate Bill 1993 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt.
Aye.
Birdwell.
Aye.
Lamantia. Menendez. Middleton. Parker. Perry. Schwartner. Zaffarini. Paxton. Use.
Aye. There being 8 ayes and 2 nays, the committee substitute Senate Bill 1993 will be reported favorably to the full Senate.
Chair now brings up as a matter of pending business Senate Bill 1600. Senator Hughes moves that Senate Bill 1600 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Betancourt.
Aye.
Birdwell.
Aye.
Lamantia. Menendez. Middleton. Parker. Perry. Schwartner.
Aye.
Zaffarini. Paxton.
Aye.
Use.
Yes.
There being 8 ayes and 2 nays, Senate Bill 1600 will be reported favorably to the full Senate. Chair now brings up the committee sub to Senate Bill 1599. Senator Hughes moves that we adopt the substitute to Senate Bill 1599. Is there objection? Seeing none, the substitute is adopted. Senator Hughes moves that the substitute to Senate Bill 1599 be reported favorably to the full Senate with recommendation that it do pass and be printed. Will the clerk please call the roll?
Betancourt.
Aye.
Birdwell.
Aye.
Lamantia. Menendez. Middleton. Parker. Perry. Schwartner.
Aye.
Zaffarini. Paxton.
Aye.
Use.
Yes.
There being 8 ayes and 2 nays, the committee substitute to Senate Bill 1599 will be reported favorably to the full Senate.
Members, thank you for working with us to get those bills moving. And we now have that one first. The chair now lays out Senate Joint Resolution 70. This is one of the 2 measures we have remaining on the agenda for today for testimony. SJR 70. Members, this is designed to place into the Texas Constitution those rights which parents are already entitled to under established U.S. Supreme Court case law. The goal of SJR 70 is twofold: to ensure the longevity of these rights by taking them from case law, which can change or go away at any time, and adding them to the Texas Constitution. Secondly, to give some clarity for attorneys, judges, and parents. A parent's constitutional rights are currently spread throughout 100 years of case law. These are cases many local judges and attorneys are simply not sufficiently educated on, as these matters do not arise on a regular basis. Certainly all of them do not. On the first goal, SJR 70 protects parental rights that are well established today, but which could change in the future if we don't make an effort to preserve them. For example, the right of parents to choose their child's method of education is protected today by the Supreme Court cases of Pierce versus Society of the Sisters, Myers versus Nebraska, Washington versus Glucksburg, and others. But new judges or cultural winds could eventually take place that put those things in jeopardy. Similarly, parents have the constitutional right to direct their child's religious upbringing, as provided in Wisconsin versus Yoder. The same risk exists there. And other constitutional rights like upbringing, custody and care, etc. Putting these rights in the Texas Constitution, we're protecting them for future generations. And on the second goal, SJR 70 does create clarity for attorneys, for judges, and for parents as we all order our conduct. Right now, a parent who finds their rights in jeopardy before a trial judge has to go through the process of educating the court on an expansive stack of case law to make sure they're properly understood and protected. And this happens frequently. Many attorneys that don't deal with these matters on a regular basis forces parents to spend tens of thousands of dollars to vindicate their rights in the appellate courts or lose them altogether. By putting these rights clearly and concisely in the Texas Constitution, SJR 70 will bring clarity and certainty. And I do have a committee substitute, which I now lay out. The committee substitute makes this a legislative council draft. That's what SJR 70 does, and I'll yield for your questions. Thank you, members. We'll begin with invited testimony, and the chair calls the Honorable Michael Massengale. Justice Massengale. And we thank him and each of the witnesses who are familiar with this process often have to wait around quite a bit. Thank you each for indulging us. Your Honor, welcome. Introduce yourself. Give us your testimony.
Thank you, Senator. Good evening. My name is Michael Massengale. I've been a Texas attorney for over 25 years. For over 12 years, I served as an appellate judge of the Texas state courts, where I helped to decide many cases involving parental rights. I served for 6 years on the Texas Supreme Court's Commission on Children, Youth, and Families. For well over a decade, I have spoken to lawyers, school children, and other interested citizens about the important role of the Texas Bill of Rights, Article 1 of the Texas Constitution, in our country's organizing scheme of dual federalism. I'm here today to support a state constitutional amendment enshrining the fundamental right of parents to raise their children free from unreasonable interference by the government. For 100 years, the U.S. Supreme Court has acknowledged the fundamental rights of parents to direct the upbringing of their children, even though that right is not expressly mentioned in the U.S. Constitution. Parental rights are worthy of very strong protection, and any governmental intrusion into the family sphere demands strict scrutiny. Traditionally, matters of family law are the province of state regulation, not that of the federal government, which was designed to exercise only limited and defined powers. SJR 70 accurately mirrors the current state of federal constitutional law on parental rights. But an important structural feature of American government is that while states may not subtract from rights enjoyed under the U.S. Constitution, each state may enact greater protections for individual liberty, as Texas has done in other areas of law. And this is the genius of dual federalism, that each state enjoys the power to develop constitutional traditions that reflect the unique concerns of the local community. So while court precedents reflect consensus about the general contours of parental rights as articulated in SJR 70, those have been developed by courts as a matter of constitutional law, and without vigilance, those principles are at risk of shifting over time. As a distinct sovereign responsible for establishing the civil law governing family relations, it is entirely appropriate for the people of Texas to enshrine the fundamental right of parents to control the upbringing of children, for the very same reasons that the founding generation enacted the Bill of Rights, to elevate important aspects of individual freedom and liberty. And parental rights occupy that same level of primacy as equality under the law, freedom of worship, freedom of speech and the press, and due process of law. And thus it is appropriate to memorialize the importance of parental rights in the Texas Constitution. I appreciate the invitation to testify before the committee. Thank you.
Your Honor, thank you for your testimony. Members, any questions? Justice Massengale, thank you very much. Thank you for being here. The chair now calls Andrew Brown. Andrew Brown, and after Mr. Brown, we're going to open public testimony. And so after he testifies, we'll be looking for Jeremy Newman, Denise Seibert, Michelle Evans, and Robert Green. Mr. Brown, welcome back. Introduce yourself. Give us your testimony.
Thank you, Chairman Hughes. My name is Andrew Brown. I serve as Associate Vice President of Policy for the Texas Public Policy Foundation, where I oversee our work on child and family issues. As an attorney, my primary area of focus are the child welfare system and parental rights, which often go hand in hand. Thank you for the opportunity to testify in support of SJR 70. Both the United States and Texas constitutions have long recognized that the right of parents to direct the care and upbringing of their children is a fundamental constitutional right. Constitutional jurisprudence on this matter is well settled through a consistent line of cases stretching back for 100 years. SJR 70 represents a continuation of this history by finally enshrining this most fundamental of rights in the Texas Constitution. The United States Supreme Court has ruled that the right of parents in directing the care and upbringing of their children is expansive. The 1979 case Parham v. JR, the court explained, our jurisprudence has historically reflected Western civilization concepts of the family as a unit with broad parental authority over minor children. This right is so broad that the Supreme Court, a few years later, in a case called Santosky v. Kramer, recognized that state deference to parental decision-making extends even to situations where parents have not been, quote, model parents. And although parental rights are expansive, they are not unlimited. It should go without saying that parents do not have the right to abuse or cause intentional harm to their children. In such cases, the state has a legitimate interest in stepping in to protect children, and in some cases, removing them from their homes if they are in immediate danger of harm. Even so, since the parent-child relationship is a fundamental right enjoyed by both the parent and the child, the state's intervention is subject to strict scrutiny and must be narrowly tailored, a fact that SJR 70 recognizes in its text. Few have done a better job of encapsulating a century of Supreme Court jurisprudence in one sentence than Justice Sandra Day O'Connor. Justice O'Connor summed up the court's history of parental rights decisions in the 2000 case Troxel v. Granville, writing, quote, the liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court. SJR 70 faithfully follows what has been established through a century of constitutional precedent. It clearly and simply communicates the fundamental right of parents to direct the care and upbringing of their children, while also explaining the circumstances under which the government may intervene in the private realm of the family. Thank you, Senator Hughes, for your work on crafting this excellent piece of legislation that we're proud to support.
Thanks for your testimony. Senator Perry, any questions for the witness? Thanks for being here.
Thank you
very much. The chair now calls the following witnesses, Jeremy Newman, Sean Hall Lacona, Denise Seibert, Michelle Evans, Robert Green, Jennifer Fleck. Again, we have Sean Hall Lacona, Jeremy Newman, Denise Seibert. We're also looking for Michelle Evans, Robert Green, and Jennifer Fleck. Ms. Seibert, looks like you're in the first position. Please introduce yourself again. Give us your testimony.
I'm Denise Seibert. I'm representing myself. I'm in support of SJR 70. I agree with the protecting a parent's right to raise their children. The state shouldn't interfere with the fundamental rights of parents to raise their children. The liberty of a parent to direct the upbringing of a child should belong to the parent. That right should include the care, custody, and control and education and moral and religious training and medical care. The state or political subdivision of the state shall not interfere with the rights of the parent unless a child is endangered. I believe that the government and state should always be limited when it comes to interfering with parents' guidance, and this COVID situation made it tough on the parents being forced with their kids. And so I'm in support of SJR 70, that parents being parents for their children. And I thank you, Senator Brian Hughes, for this bill.
And thank you for your testimony. Ms. Lacona, welcome back. Introduce yourself. Give us your testimony.
Yes, my name is Sean A. Hall Lacona, and with all due respect, please take no offense. I stand against SJR 70. There is a supreme judge over all. He intervened to save my daughter's life on November 9th, 2020, against the adversary. Chairman Hughes and the State Affairs Committee of the 88th Texas Legislature, I hope you're having a good day, because I am. I will continue to speak the truth forevermore. Love reigns in justice. I stand against SJR 70, knowing in God we trust. He was the one that day, and many others. It's been 15 years that it took for us to get to the place where we could speak the truth in the U.S. Supreme Court. For unto us a child is born, unto us a son is given, and the government shall be upon his shoulder, and his name shall be called Wonderful Counselor, Mighty God, Everlasting Father, Prince of Peace. Of the increase of his government and of peace there shall be no end upon the throne of David and over his kingdom, to establish it and to uphold it with justice and with righteousness from the time forth, even forevermore. In good faith I have obeyed law, he upholding oath provided by the law of the state of Texas. You should too. An institution of higher education continues violating Christ, notwithstanding Article 3, Section 3, Paragraph 2, 21st word of the federal Constitution. But I'll create praise on their lips, perfect peace to those both far and near. I'll heal them, says the Lord. I quoted Troxclair to them. Nevertheless, here I am today, mentioning Troxclair again. Overcomers, no hospital ever healed. May I finish?
Go ahead.
No hospital ever healed any member. Almighty defeated death on the cross, making the way of life. Continuing the way church schooling has always been my fundamental right. For yours is the kingdom and the power and the glory forever. Amen, and it shall come to light what I'm saying. I tell you, it's the truth. Thank you for listening and understanding.
Of course. Thanks for your testimony. Mr. Newman, welcome. Introduce yourself. Give us your testimony.
Thank you, Chairman, members. My name is Jeremy Newman. I'm the Vice President of Policy Engagement for the Family Freedom Project. And a couple witnesses before me have kind of already laid out the history of the federal case law on this topic. And so I really want to hone in on a couple practical observations that, as has been mentioned, we have 100 years of history of law here. And so myself and a few other people had kind of collaborated on the language in the committee substitute. And The goal behind that was to figure out how do you take 100 years of case law and condense it into something that is concise and word for word a representation of that case law. And that's how SJR 70 came about, was trying to accomplish that goal. And more than a few legal scholars were involved in that, including Justice Massengale and Justice Ava Guzman, who isn't able to be here today. But kind of the follow-up question that would naturally come from that is, well, if it's already in the law, and it is, all of it is in SJR 70 is already the law, then what's the point? Like, why do you need it? And I think, Senator Hughes, that you laid this out well in your opening, that there are kind of two main goals that it accomplishes. The first one is that it ensures the longevity of all of those rights, because right now, all of them exist only in U.S. federal case law, and that can come and go depending on the appointment of new federal judges. And so putting it in the Texas Constitution just ensures the longevity of what we already have. And the second point is clarity, and I kind of brought a visual aid for everybody for the benefit here, that 100 years of case law that we talked about, if you were to walk into a court in Texas and find yourself in the position of having to explain to that trial judge what all of your rights were under the U.S. Constitution, this is what you would have to explain to them. And the probability of being able to explain that to them, especially if you don't have an attorney who happens to be well-versed on the law, is just really difficult. And unless you can afford to get to the appellate courts, the probability that you're going to lose those rights is high. So it is all exactly what's in the law already, but because it ensures the longevity and the clarity of those rights, I think it's important to pass SJR 70.
Thanks for your testimony. Any questions for any of our witnesses? Thank you each for being here. Thank you very much. Is there anyone else present wishing to testify on, for, or against Senate Joint Resolution 70? Seeing and hearing none, public testimony is closed. Bills left pending at this time. The chair now lays out Senate Bill 1281. 1281. This is has to do with the failure to appear pay program. And Senate Bill 1281 is addressing a concern that's arisen over time, because under the current program, a person cannot renew their driver license until all of their court fines and fees are paid in full. And so on its face, that sounds reasonable, but the effect has been Texans unable to legally drive, not because of dangerous driving behavior, but just because of unpaid debt, most often for traffic tickets. When people can't drive, of course, their ability to obtain and keep employment is affected. We can certainly all identify with that. Many continue to drive, which results in more tickets and trapping people already struggling with poverty in an endless cycle of debt. And so Senate Bill 1281 would repeal the failure to appear pay program and allow Texans the ability to settle their fines and fees without getting caught up in this cycle. That's what the bill does. It's pretty straightforward, and I'll yield for questions. We'll open up testimony, and with invited testimony, we'll call Samuel Sheets. Samuel Sheets. Welcome. Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. My name is Samuel Sheets. I'm the Legislative Director for Americans for Prosperity here in the state of Texas. I'm also representing the Smart on Crime Coalition here in the state of Texas to talk about driver's license suspensions, which you've laid out, Mr. Chairman. I'll just get straight to the point. The failure to appear program, the Omni-based system, is the driver responsibility program resurrected by another name, which we are also very proud that we repealed back in 2019. It passed unanimously out of the Senate. It passed unanimously out of the House. There was major consensus on this program, but it is still sticking around under the guise of Omni-based and failure to appear. So back in 2019, about 1.4 million holds were lifted when the driver responsibility program was repealed. That sounds great, but 50% of those people still could not get their driver's license back because they had unpaid fines and fees. So again, nothing to do with dangerous driving behavior. This just comes back to unpaid debts. So these people, they're unable to clear the holds, and they're stuck in this endless cycle. They have all these fees, but they can't drive to work to make the money to pay the fees. So they just, it goes round and round, and they're stuck. So this is also confusing for the Department of Public Safety. It's difficult to get clarity to these people, the status of their driver's license. So they're overwhelmed on the DPS side. It's confusing for the citizens. And I'll just wrap this up really quickly. I see I'm running out of time. So a lot of other states have already addressed this issue. Tennessee, for example, stopped suspending driver's license from 2018 to 2021, and they saw no significant difference in the rate of collections. There was no drop-off. There was no noticeable difference. Here in Texas, we've been doing this at the local level. The city of Dallas has opted out of the contract. Harris County has opted out of the contract. The city of Austin has opted out of the contract. Again, no significant difference in terms of rate of collection. If anything, in the city of Dallas, they're collecting $45 more in the paid tickets. So if anything, compliance cost goes up. And then lastly, my favorite statistics, we all love making fun of the state of California, myself included. I have a lot of family on the West Coast. They repealed their suspension program, and they saw their compliance go up by 8.9%. So we have a lot of data on this issue. We're supporting it 100%. There's hundreds of thousands of Texans who are stuck in the cycle. And Mr. Chairman, thank you for bringing this bill that can really help a lot of people in the state of Texas.
Well, thank you for your testimony. See if there's any questions. Very good. Thanks for being here. And we'll open testimony and call Victor Alcorta, Mary Mergler, Fernando Martinez, Nikki Presley, Ms. Alcorta, if you're ready, you go. We'll let you go first and just introduce yourself, give us your testimony, and we'll go from there.
You got it. Good afternoon, Chairman Hughes and members. My name is Victor Alcorta. I'm an attorney representing Omnibase Services of Texas, testifying against SB 1281. Omnibase contracts with participating counties and cities to service the FTA program on behalf of DPS. SB 1281 would repeal this program without providing courts any other tools to achieve compliance. Most states have FTA programs to enforce traffic laws, but this Texas model is unique. This program does not suspend driver's licenses. Rather, it places a hold on driver's license renewal, and a person is free to drive illegally until their renewal date. There is an exemption for the indigent. The program is not mandatory, and it isn't designed to maximize revenue. Rather, its purpose is to achieve compliance by granting broad judicial discretion. This program is voluntary. Counties and cities don't have to participate, and when they do contract with DPS to participate, judges still don't have to use it. It's completely discretionary. Yet 97% of Texas counties and more than 800 cities choose to use the program. Many courts prefer this program because it's a passive compliance tool, meaning it's an administrative tool rather than an invasive one, as with the use of warrants. Individuals receive at least 3 written notices about the FTA program prior to their driver's license renewal date. Individuals that have a renewal hold may still be eligible to obtain an occupational driver's license to drive legally while in the program. It's important that you know that UT San Antonio recently evaluated the city of San Antonio's use of the FTA program and concluded the following. The program doesn't target poor and minority communities. The poor and minorities are not disproportionately affected by the program. The program is effective at getting people to appear in court, and the court does not use the program punitively. If this program is repealed, we will likely see an increase in failures to appear across the state and will absolutely see a greater use of warrants. In closing, if counties and cities don't want to use the program, so be it. But please don't take this compliance tool away from the vast majority of Texas counties and cities that are choosing to use it. Thank you, Chairman Hughes and members. I'm happy to take my medicine.
Mr. Alcorta, thanks for your testimony. Any questions from Mr. Alcorta? Very good, thanks. We'll come back over here and we'll go to my left, to your right. We'll go from right to left. Introduce yourself. Give us your testimony.
Thank you, Chairman. My name is Nikki Presley. I'm the Texas State Director for Right on Crime at the Texas Public Policy Foundation, and we are in support of SB 1281. The Failure to Appear or Omni-Based program was initially established with the goal of improving appearance rates and payment of fines and fees. However, the program has failed to actually achieve that goal. Instead, the program is placing holds on these licenses and not allowing people to reinstate their license, all due to unpaid fines and fees that are not actually related to unsafe driving. When someone's unable to renew their license, they face substantial barriers to transportation and therefore employment, which is counterintuitive to the goal of the program. Additionally, if someone were to drive out of necessity, for example, to get to work, they would be unable to obtain vehicle insurance, therefore increasing the number of uninsured drivers on the road. So repealing this program would be basically completing the repeal of the driver's responsibility program. And thank you for your time.
Thank you for your testimony. Welcome. Introduce yourself and go ahead.
Thank you, Chairman Hughes, members of the committee. My name is Mary Mergler. I'm with the Fines and Fees Justice Center. I'm testifying in support of Senate Bill 1281. And thank you, Senator Hughes, for filing this critical legislation. The Fines and Fees Justice Center, or FFJC, is a national hub for information, advocacy, and collaboration for reform of fines and fees across the country. But while we are a national organization, I'm based here in Texas, lived and was raised in Texas, and for many years prior to joining FFJC, worked on fines and fees policy in Texas, including the Omni-Based program. I think other witnesses will speak more in depth to the harms caused by the Omni-Based program, how it creates needless barriers to employment for 454,000 Texans, how it leads to $5.6 billion in lost earnings annually. What I want to speak to briefly, though, is just how Senate Bill 1281 and repeal of the Omni-Based program would fit into the larger movement happening across the country to end debt-based driver's license restrictions and suspensions. In just the past 5 years, 24 state legislatures have passed legislation along the lines of 1281 to end or significantly curb debt-based driver's license suspensions, including Arizona, Idaho, Mississippi, Montana, Utah, Virginia, West Virginia. Most recently, the New Mexico legislature passed a bill to end license suspensions for non-payment of fines and fees that was signed into law last month. In addition to Senate Bill 1281 in Texas, legislation is being considered in at least 8 other states this year as well, including Oklahoma and Florida. There is a growing and now very widespread recognition among state policymakers that preventing someone from driving because they haven't paid their fines and fees does far more harm than good. And this legislature has already recognized the cycle of debt and incarceration created by the driver responsibility program and repealed that in 2019. Repealing Omni-Based is the next logical step to continue that work and ensure that people their freedom to drive is not based on how much money they have. Thank you.
Thanks for your testimony. Welcome. Introduce yourself and give us your testimony.
Good evening, Chair and members. My name is Fernando Martinez, Jr. I'm here to testify on behalf of myself in support of SB 1281. I have felt the effects of not having your driver's license. I'm 40 years old, married, and have 2 kids, and have been driving for 22 years. 16 of those years were without a license. When I was 19, I got a ticket that I wasn't able to afford. I entered a work zone. There was an obstructed work zone sign and no other indication that road work was going on. I received a ticket that I couldn't afford, and my license ended up getting suspended. Not having a license hindered my ability to progress. I still needed to go to work and provide for my family. I work construction, so taking a bus with tools and material wasn't an option. I ended up getting pulled over on my way to work and was charged with driving with a suspended license. This charge put me in an endless loop of additional suspensions, fines, and fees. This affected my progress of my career because no employer wanted to hire someone that ran the risk of getting arrested every day on the way to work. With the amount of time off I needed for court and community service, my employer saw me as unreliable, which didn't put me in good standings for a raise. I also couldn't get a company vehicle without my license. Without a license, when my vehicle was in the shop more than on the road, I couldn't buy another vehicle. It affected my home because I ended up having to pay tens of thousands of dollars in fines and legal fees. Not to mention, my wife was stressed every time I left the house, in fear that I would get arrested and the only vehicle we had would get impounded. After a long, stressful road, I ended up getting my license back. In the short time that I've had it, my income has more than doubled. I now have a company vehicle, and with the money not being spent on attorneys, fines, and fees, I was able to move my family out of a rundown mobile home and was able to purchase a large house. I credit all my success to having my driver's license. Again, I can't stress how much not having a license hinders somebody's ability to prosper.
Thank you for your testimony. Senators, any questions for any of our witnesses? Thank you each for being here. No, he testified first. Go ahead.
Just for the record, in 2017, you'll remember there was a lot of reform to address what was called debtors' prisons, right?
Yes.
And judges were granted discretion, broad discretion, to waive fines and fees in part or in full. That is current law. So to say that everything has to be paid in full before the hold is lifted is simply not true. Today, judges have judicial discretion to lift the hold when someone enters a payment plan or community service. It does not have to be fulfilled. So I just wanted to clarify that.
No, thanks for that. Senators, any questions for any of our witnesses? Very good. Thank you each for being here. The chair now calls Sarah Mae Jennings, Emily Garrick, Monica Sanchez, Jennifer Carrion, Lourdes Zuniga. We're looking for Sarah Mae Jennings, Emily Garrick, Monica Sanchez, All right, welcome to each of you. We'll begin over here on my left, your right. Please introduce yourself and go ahead with your testimony.
Thank you, Chairman. Members of the committee, my name is Lourdes Zuniga, and I am the Executive Director at the Financial Health Pathways. And I am here testifying on behalf of my organization and myself in support of SB 1281. For the past 4 years, we have been operating at my nonprofit a program that works with the courts in exchange of, and minor traffic offenders in exchange for waiving the fees and dismissing the cases. Very successful program. And this program has been designed to help people who owe fines and fees that they cannot afford, and it holds them accountable for allowing them, while also allowing them to avoid harmful omnibus holds. The people that come through the doors are people that either have grown up in different countries and moved to the U.S., have not been exposed to the legality of fines and fees and tickets and traffic offenses, but also the long-term consequences of having a license being taken away and everything else that comes with having a record. We believe that by providing them an alternative way to resolve this issue, we can actually help them not go further into poverty. And I urge you to support SB 1281 and eliminate driver's license holds. In their place, we can expand programs like mine that hold people accountable, and they also help them move with their lives and build their wealth. Thank you.
Thank you for your testimony. Welcome. Introduce yourself and go ahead with your testimony.
Good afternoon. My name is Monica Sanchez, and I am testifying in support of SB 1281. Almost 1 million Texans had their license suspended by the Omnibus program, and I am one of them. There are other individuals who have a hold on their license or have it suspended, and they can't be here today to testify. I was in the middle of buying a car, When I realized that my license was about to expire, I went to renew it, and instead of getting the renewal in the mail, I received a letter from DPS stating that my license was suspended. So from that moment on, I had to start riding the bus. You might ask yourself why I'm in this position, and I suffer from complex PTSD and anxiety due to childhood and divorce trauma. I was going through a divorce when I received some of these tickets, and that period of my life is a complete blur. Not being able to have a driver's license has impacted my life in many ways. I was let go from my government agency after 3 weeks. HEB refused to give me a refund even though I had a receipt because I didn't have a valid ID. I can't get an apartment in my name. My bank account was closed because I no longer have a valid ID. And 2 years after my license was suspended, I'm near the end of paying off all of the fines that I owe, but I'm not done yet. This has been a hardship for myself as a single mom to 2 kids, and I don't have anyone else to help me. Being in the OmniBase program has added to my daily stress and struggles. As you ponder whether to keep this program or not, please take into consideration not only my testimony, but the testimony of other individuals who cannot be here today who are in the same situation as I am. Thank you.
Thank you for your testimony, and welcome. Introduce yourself, give us your testimony.
Thank you so much. My name is Emily Garrick. I am very much in support of this bill. I am a lawyer. I have been for almost the last decade trying to help people who have OmniBase holds, and so I just want to say from the bottom of my heart, thank you so much for this bill. It is so important. I can say that back when the driver responsibility program was around, the vast majority of the people that I work with had both DRP suspensions and OmniBase holds. There's functionally very little difference, and the differences that there are actually make it so that it's much easier to take care of a DRP suspension than an OmniBase hold. And the reasons for that are many, but basically when someone came to me and they had both of these things, I'd be like, okay, we can take care of the DRP suspension, no problem. But the OmniBase hold is going to be really difficult. There's a few reasons for that. One is they're all over the place. So if you were driving through Texas and you got one in a really far away jurisdiction, then that's something, if you don't have the money to pay it, you're going to have to actually go there and actually try to get on a payment plan or something. And then even if you actually do that, even if you're on a payment plan, you might get that $10 fee waived. I guess that's what the lobbyist for OmniBase Services Texas that runs the program meant. But there's no indigency program. That hold doesn't lift for every single of the over 100 people that I've represented. That hold doesn't lift until you fully pay off everything. And that means that if you're on a payment plan or community service plan, as you're driving to work, as you're driving to a community service site, you're going to get another ticket, another hold. You're going to be trapped in that cycle of debt. And I can also say that the vast majority of people who have tickets, they're never going to see a judge. So the judge having discretion doesn't really matter. The only person they're going to see is a clerk who's going to put them on a payment plan or a community service plan, and that hold's not going to lift, and they're going to be trapped in a cycle of debt, and they're likely going to eventually end up in jail. I can also say that there's absolutely no data supporting that warrants would go down. They actually go up in jurisdictions when you compare jurisdictions that use OmniBase versus don't. And I'm out of time, but thank you so much.
Thank you for your testimony. Welcome, introduce yourself, and go ahead with your testimony.
Thank you, Chairman Hughes and members. My name is Sarah Mae Jennings. I'm the Interim Co-Executive Director and Policy Director at the Texas Fair Defense Project, here to express our strong support of Senate Bill 1281. In 2019, Texas made history by repealing the Texas Driver Responsibility Program, under which over 1 million people had their licenses suspended for non-payment of government debt. However, many Texans were disappointed to discover that they still could not get their driver's licenses back, most commonly due to a very similar program run by private contractor OmniBase Services. Under the OmniBase program, nearly 1 million Texans have lost their ability to obtain or renew their driver's license until they pay off fines and costs from low-level traffic tickets. Each of these Texans with OmniBase holds has an average of 3 to 4 unresolved tickets and must resolve over $1,000 in legal debt to reinstate their license. The OmniBase programs leads to license suspensions, not because people are dangerous drivers, but because they cannot afford their fines and court costs. OmniBase holds trap Texans in a paradoxical cycle of debt. In order to pay off their tickets, individuals must drive to work and/or community service, but if they continue to drive, they risk getting pulled over and receiving more tickets, more fines and fees, and additional suspensions on their license. If they do not continue to drive and are unable to attend court, community service, or get to work or to earn income to pay off their tickets, they risk incurring more omnibase holds and warrants for their arrest. The omnibase program does not do what it purports to do. There's no evidence that using the omnibase program increases revenue for the courts that use it. As of 2021, the average amount collected was actually lower for courts that had opted into the omnibase program than for courts that had opted out. Repealing the omnibase program will remove barriers for the nearly 1 million Texans who are impacted by the omnibase program, increasing the number of licensed drivers on the roads and thereby improving public safety and reducing unemployment and lost wages in Texas. Thank you for your favorable consideration of Senate Bill 1281. I've also attached a frequently asked questions page to the back of my testimony. Thank you.
Thank you very much. Welcome. Introduce yourself. Go ahead with your testimony.
Hi, thank you, Chairman Hughes, the committee members for having me today. My name is Dr. Jennifer Carrion. I am the director of the Criminal Justice Project with Texas Appleseed. We are here today testifying in support of Senate Bill 1281, and thank you to Senator Hughes and Senator Parker for authoring such a great bill. There are three main points that we would like you to consider whenever taking into consideration SB 1281 up for vote. The first is that, as many of my colleagues and witnesses have testified before you, is that it is a debt-based trap. We are witnessing bipartisan and national support away from debt-based driver's license suspensions or renewal holds, if you will, as they have been found to be ineffective and counterproductive, which leads me to my second point. To remove a mechanism that is legally required to get from point A to point B, so from home to work to the court, and what is necessary to even obtain employment to pay said debt, is just bad policy. Simply put, we can do better. There are alternatives, for instance, that have shown by research that they are effective. The third point is that the failure to appear program does not do what it claims to do. You've heard this several times. Texas Appleseed has spent the last 5 years intently empirically examining this program, and what we have found is, just as you have heard, revenue does not go up. There's no difference between those jurisdictions that use omnibase or the failure to appear program and those that don't. The difference is insignificant. It's $45.44. Those are jurisdictions that use FTAP actually earn less than those that do use it. In addition to that, we also found that there is no procedural justice going on here. Jurisdictions that are using failure to appear program are actually issuing warrants, capious warrants, at a 1.3 rate times higher than those that do, and Class C warrants 2 times higher than those that do. I will just say that there are roughly 1,750 local courts in this jurisdiction that would be affected by this or are affected by this. Our sample size was over the sample size that was required to make a general finding. We looked at 800 courts when we looked at the difference in revenue collected, and we looked at 790 courts when we looked at the difference in warrants. The sample size that we would need to generalize that to the state is 315. So, significant.
Thanks for your testimony. Senator, is there any questions for any of our witnesses? Thank you each for being here. Thank you very much. We have one more witness registered to testify on Senate Bill 1281, and it's Jesse Palmares. And if there's anyone else wishing to testify on, for, or against Senate Bill 1281, please register on the kiosk outside. And welcome. Whenever you're ready, introduce yourself and give us your testimony.
Hello, my name is Jesse Palmares. I am here on behalf of Prison Fellowship in favor of this bill. I'm here because I believe that this bill will take down a lot of the barriers that are keeping people from gainful employment. As a formerly incarcerated person, I've been given a second chance. Not only am I a custodial parent of 2 kids, I'm also a registered nurse. I've been practicing as a nurse for over 20 years. But my life didn't always start like that. At the age of 19, I found myself in the county jail facing a charge of murder. I was involved in a gang-related shooting that left a man dead. And at that point, I really felt like my life was gone. I felt hopeless, despaired, and so I thought about, what about God? So I opened up the Bible, and I was shocked because in Galatians it says that no murderer, no adulterer, no fornicator, no liar will be able to inherit the kingdom of God. So I thought, okay, I'm done. My life's over. Shortly after, a man came to the prison and asked, to the jail, and asked if anyone needed prayer. And I went up to him with a little bit of animosity and thinking, what is your God going to be able to do for me? And he asked me if I ever heard of Jesus Christ. And I told him, my mother has a picture of him in my room, but I don't know him. And he said, well, God loved you so much that he sent his son to die for you on the cross. And at that moment, I said, well, what do I need to do to be saved? And he led me in the sinner's prayer. I got out of prison. I didn't have a driver's license because I was only 19 when I got convicted. And it allowed me a chance to get my CDL license. My mother would have to take me places for jobs, and just having a driver's license opened up so many doors. When my son was 4 months, he almost died. That inspired me to become a nurse. And through all these barriers that we as formerly incarcerated people have to face, I believe that giving people a second chance will help them to prosper. And all we're really looking for is a chance at life and liberty and a pursuit of happiness. And I'm in favor of removing this barrier. Thank you.
Thank you for your testimony. And I mean testimony in more ways than one. Thank you for sharing that with us. Anybody got questions for the witness? Thank you for sharing your story. Thank you for being here.
Thank you.
Is there anyone else present who wishes to testify on, for, or against Senate Bill 1281? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. And Senators, we have motions in writing from Senator Middleton and from motions in writing from Senator Middleton, Senator Saffarini, Senator Birdwell. Without objection, those will be adopted. And if there's no other business to come before the Senate Committee on State Affairs, the committee stands in recess up to call the chair. Good evening.